Welcome to our webinar today with Enza Iannopoulos from Forrester. And we'll be talking about Enza's predictions for 2021 from a privacy perspective. We're delighted to have a terrific group of attendees today. And Enza, as you know, part of the normal world now for us as we start a webinar is we have to wait a few minutes as our attendees join. So we're just going to give it 10-15 seconds here as folks actually join the webinar. And then I'm really looking forward to a terrific discussion today with Enza around a piece that you've published around privacy predictions for the year. So first of all, Enza, great to see you here today. I really appreciate you joining us here at WireWheel to talk about the piece you've written and that you published last year on 5 key predictions for 2021. As our viewers also know, your writings from the Forrester side and your analysis in the privacy industry are widely followed, both from a policy perspective, also from a technology perspective. And so our team is delighted to have you here today to talk about your background, some of the work you've been doing on the Forrester side, but of course, most importantly, your privacy predictions for the next year. So Enza, welcome, and thank you for joining us.
Thank you for having me, Justin. It's a pleasure to be here today, and it's a privilege to be able to share this prediction. Now, after the year we all had in 2020 with so much uncertainty, certainly it took some courage to sit down and think about prediction for 2021, but I think it's always very helpful. I see it from my clients. It's helpful to have some indication of what to expect, and also use that also as an indicator to see whether there is alignment, there is the same sort of expectation, there is the sort of trends really, because beneath those predictions, really there are trends that we see that we identified. And so it's always a good discussion with our clients. I know that they expect this kind of documents every year, and I'm delighted to be able to speak about it here today with you. I know there are many points that we will look into. Now, before I probably dive into the specific prediction and we have that discussion, there is something that I wanted really to place at the very beginning of this document and just make a point very clear. I think that privacy professionals today understand this very well, but sometimes the larger organization might struggle to see it. Privacy is about requirements, is about regulation, is about compliance, and this will stay, and this is absolutely important. And we do privacy because we have a duty to comply with those requirements. We have a duty also to do the right thing for our employees, for our consumers. But I think that even this year, I mean, 2020 and the beginning of this year gave us really one more opportunity to see the implication of privacy in real life, the implication of privacy, or I should say, undermining privacy can really have a strong impact on people's life. And people sometimes don't see that, but I just give you a very short example. I'm Italian, as I'm sure everyone already is aware of by my accent, but I've been living in the UK for a long time. And this summer, of course, many students finishing high school, they couldn't take their exam. So the UK government decided to use an algorithm to actually calculate the grades of each of these students. Now, the way that algorithm was built was as such that actually schools were, which smaller classrooms would actually be rated in a better way than schools with larger classroom, because there was an average number of previous year's results, and similar schools in a wealthier neighborhood as an advantage, because they were designed to be generally smaller in the distribution of the classroom. So because of the way that algorithm was built and was trained, it happened that actually students that came from less wealthy background saw their opportunity to go to certain university forbidden to them because of the algorithm. Some of them felt that really was unfair to them because they were going to school, they were, larger and they were state-owned. Simply their possibilities were limited, not because of their abilities or because of their performance, but really because there was something wrong with the data that was feeding that algorithm and the way that algorithm was built. Now, this gave me an opportunity to say, wait, there are some specific procedures that have to happen when we use technology to automate decisions of this kind. The GDPR is clear on that. A lot of the private frameworks for trustworthy artificial intelligence have that. So the need to really risk assess and be able to mitigate the risks appropriately. This is core to privacy, and this example gave me that opportunity really to see how deeply the implication of privacy and undermining privacy can actually run into our lives, into the future of our own society. And so this is really what I wanted to, how do I wanted to open this document this year.
No, and so, that's you've made a very important point, which is so many things that even in the last year that each of our communities have had to do to pivot quickly from what we used to do to accommodate a new approach in light of an emergency like COVID, required somebody thinking through the issue from a privacy and broadly data protection perspective in order to catch issues like this. And my strong suspicion is when we come out of COVID and companies are really reopening, and some of the main regulators around the world look back at what has actually occurred, you will be just scratching the tip of the iceberg in terms of the number of different accommodations or issues that actually were buried under those kinds of changes. I'm not surprised. It's a very interesting thing that you're spotting from the test taking perspective. In the US, for example, we haven't seen automated decision making regularly included in the privacy laws in the same way. It's come up in CCPA 2.0, but usually in the US, automated decisioning and the discriminatory or other issues that come out of it are covered by other laws like anti-discrimination laws or industry-specific laws. But I'm quite confident that a lot of the automated decision-making or other accommodations are going to raise issues that you are analyzing for years. And I'll raise a similar one that I think leads right into some of your core privacy predictions for 2021. One example of this is some of the state regulations that are governing reopening our economy and reopening our offices for very good reason. Every state, and California is an important one right now, ENZA, where they have passed state OSHA regulations that put a company into a position where if there is a COVID event, the company must have a very clear way to collect a lot of information from each of the individuals about the condition, when it started, what the consequences were, and then also be able to contact trace to a number of other people in the company. Now, you and I know from a location data perspective, from a sensitivity of the data perspective, you're basically putting a lot of employers into a position where they're collecting core health core data in very sensitive data on a very short time frame. The California law, for example, went into effect in December, ENZA, and just think about all that data that companies have to collect. And are you ensuring very limited access? Do you have the right controls to ensure that it's only being used for extremely limited purposes? Is that data encrypted in a way that's justified? All of the things that you write about, I have a feeling we're going to be looking back, not only at those issues, but at a broad spectrum of them to just see whether companies really did do the right thing under the various regulations, don't you think?
Absolutely, and here I share a data point, and actually came to my mind that you were speaking. We have been asking employees how they feel during the time of the pandemic. We did a global study. In Europe, I did ask employees whether they felt comfortable sharing medical information with their employers, and also I asked them what was their expectation after the end of the emergency. Now, across Germany, France, the UK, Italy, Spain, we had a different sense of appetite for how comfortable employees were sharing this personal data with their employers. But generally, there is an understanding this is an emergency, so we really need to share some of that data. What was interesting is that across the countries, these countries in Europe, over 60% of those employees clearly said, we expect this data to be deleted as soon as the emergency is over. So really, understanding, yes, I need to share this data with you now because it's needed, but a clear expectation that that data and a clear demand that that data must be deleted once this emergency is over. So that was a clear way of seeing that employees are very much part of this privacy discussion. And actually, that was exactly my prediction number one. I expect to see employee privacy related lawsuits or legal activity really growing, I said by 100%, because 100% in 2021, but definitely there is a lot of activity there. You mentioned on one of the most important trend that is underpinning this prediction, which is all the activity around COVID. I have been part of the team of Forrester that also has been writing on pandemic management, return to work. And we have seen a number of employers everywhere really try and make sure that the workplace was safe enough, make sure that employees were comfortable going back into the workplace. This meant, of course, using technology and collecting all the data that you have been discussing. Now, they would say, this is health and safety. I have a clear duty to make sure that I comply with health and safety regulation, and privacy is something that in this moment I can forget about. That was a mistake, clearly. We have seen a lot of activity from regulators. I think that in Europe alone, globally, I think that I counted over 80 different pieces of guidance around privacy and COVID issued by a number of regulators, up to the point that some of the legal team and privacy team and HR team that I talked to said they're actually tracking all that guidance and all what was happening in the privacy world was a job in itself. Yeah. It was very difficult to stay up to date with all that sort of guidance, but companies that have thought simply, this is an emergency, I'm going to collect all the data that I want, and then I think all the data that I think I need now, and I don't care about the mitigation that I need to build in. Those companies will need to deal with the liability that they have created in the collection and processing and sharing of all this data. And there is one element. The other element is beyond COVID. It's something that I have seen happening now for some time, which is the appetite for more workforce analytics. There is a theme around employee experience that has become a priority for businesses, and there is an understanding that employee experience drives better customer experience, and customer experience drives profits. And so clearly everyone is trying to improve that employee experience. This means that you want data for benchmarking purposes, you want data for performance, you want data for a number of reasons. And some organizations are simply thinking that, I just take the data that I have of my employees that I've collected for different purposes, and I just stick into my analytics projects, and I am done. Clearly, you cannot do that. There are specific purposes when the employee data has been collected, and there is something that this is not something that you just take from one system, you move into another system, and you are done. There are important implications there. But once more, I don't think that everybody that is now engaging into the workforce analytics projects is doing that with a privacy by design mindset. And this is why I think we are going to see a lot of that activity around employee privacy. We saw a few things already. In Europe, there was, the fine against H&M for storing too much information, too much data, personal data of their employees. Is interesting because a lot of that was actually unstructured data, leaving emails or chat conversations. So something that is very tricky in a way to track. But also in the US, we have seen a few cases where actually courts are saying there is an expectation of privacy in the workplace in the US too. So for those that think that in the US, these kind of conversations are a little bit more difficult to happen, I would say, wait and see, because actually we are starting to see the clear signs that is something really changing around employee privacy. Justin, that was a long comment. I don't know whether you agree or...
It isn't at all. It's a very important one. And it's probably one that most companies are worried about that we're seeing, Enza. And I think you're spot on. What I'm sort of taking away from your main points, COVID and the fact that you have to comply with regulations will not protect you if you're a company in some blanket way. When you're having to collect extremely sensitive data. It's just not going to be some global immunity. There are a number of laws in the US that are being proposed around the balance between privacy and immunity around opening offices, but none of them have passed yet. And so right now, if you're a company and you're having to comply with this data collection obligation, around reopening your office, I think somebody in your organization has to think about all of the normal privacy and security checkpoints on that data, make sure it's securely captured, make sure it's limited access and limited use. And even in light of all of that, and Enza, I've seen this in some of the legal, the sort of proposals out there, even with all of that, you may be put into a position at some point in which your company receives a regulatory or a national security or a law enforcement request in which that same very sensitive healthcare data would be at issue. So there's only limited things the company can do even with the COVID protections, but it's very, very good advice to be thinking about that. On the broader analytics front, I do think there are more companies doing analytics against the data they're collecting on their employees. I share your view that if your company starts analyzing the emails and other things, even if, you have to be very careful on thinking that just a broad waiver will give you the authority to do every kind of analytics, because I just don't know where the regulators are going to see that. So I think it's a great area for focus.
Interesting, yes, the regulator, but it's also this aspect of employee, your ethics, right, as an employer. I think that your employees have the right to know which kind of analytics you're doing with their data, how you're using their data. So it's beyond that idea of, yes, regulators and fines. Of course they are, and we will see that activity. But I think there is this very fundamental aspect of corporate culture and ethics that are also to come to place where because you have that data available somewhere in the organization, it doesn't mean that is at your disposal and you can do what you want with that data. And then on the COVID side, just one more thing. I know that we have a lot of privacy professionals in the, that are parts of the conversation today. One of the typical things that I have seen when I went to do the interviews for those companies that were preparing their return to work strategy, pandemic management plans, one of the typical things that I would find is that actually very often it was HR professionals that were putting together the policies and the technical requirements for the data collection and processing of these sensitive data. Now, they would leverage their typical classic HR policies. And that was, for me, a clear red flag, because this is exceptional. This is exceptional for the sensitivity of the data. This is exceptional for the amount of the data that we are collecting. Therefore, the more typical HR policies are not going to make it. So the really the thing there is a privacy professional those HR colleagues that you have, they really need your help. And even if they are relying on their existing policies, they are not gonna make it against these exceptional risks that we are creating. So there is the need to go and really support them if you haven't done it already. But a lot of organizations were working that way, having HR applying their own policies on something that is very not business as usual.
And I agree with you. And I do think that point naturally leads into your second prediction, which is, and I'll let you cover this because it's an important observation and prediction that is driven around the fact that privacy and data protection is such a cross-functional issue in so many companies. I can talk about that in a little bit, but I'd love for you to cover this second prediction first.
Sure, Justin. We have, I was observing a lot of change in privacy organizations anyway, since, early days of GDPR compliance, there were these organizations that were sometimes even not formally existing in a way. And there were many that were actually taking care of privacy for their organization, but without necessarily the title of the people. Now, privacy teams generally have remained small teams. I haven't seen, privacy team becoming enormous. They are typically small, but they are becoming much more strategic. And this is a little bit what is behind this prediction around 40% of privacy leaders that will report into CEOs. And I saw that because, first of all, this collaboration element. Privacy officers, privacy teams collaborating with HR for the purpose of COVID, for example, but they are collaborating more and more with their chief marketing officers because there are a lot of activities around the collection of consumers' data and how to use that. And therefore, they need really to be there as part of that conversation. But they are also a big enabler of data monetization projects, for example, an organization trying to make that happen. You need to have assurance that where you have done collecting the data, the way you are treating that data is actually compliant with all the rules and regulations. Therefore, privacy has a very strategic role to play there. And they are also having very close relationship with data governance, with security. The fact that you have this team in an organization that really is working across a number of stakeholders means that really the privacy team needs to have, and the privacy officer needs to have the visibility across that organization. We see a lot of organizations starting to recognize the importance of privacy, especially those that also recognize that privacy is a regulatory requirement, but it's also a value that they want to embrace and a value that their customers really care about. We have data now suggesting that consumers do pay attention to the values that companies choose to embrace. And they also are vigilant and want to understand whether actually there is integrity behind the choices. And therefore, if I say that privacy is important to me, I behave in a way that actually reflect that commitment. Consumers tend to buy, they prefer to buy from companies that have this sort of values-based approach and this sort of values commitment. Sustainability is a value that we see often being prioritized, but the number one remains still globally the data privacy and confidentiality of information. So there is that strategic element really coming to place, which is not just the need to collaborate because of the requirements that you have to follow, they need to collaborate at a strategic level because it's about innovation, it's about new opportunity like data monetization. And it's also about really make sure that you understand the sentiment of your customer and you are able as an organization to do the right thing to make sure that these customers feel reassured that they can work with you and you are someone they can trust. And privacy can deliver on all of these items.
Again, Enza, I think this is an important observation because, again, the way you've framed it, it's not only that privacy and data protection has become a regular board conversation because of the risks, but it's driven by this need to drive collaboration across your enterprise. And even the way your WAVE reports and others are structured, it's bringing together on a multifaceted basis a lot of the practices inside a company. So from the technology perspective, for us, it's been absolutely critical to have, and we see this in company after company, to make sure that the privacy compliance office has the right tools to be able to show that the company is compliant. But in almost every company we're working with, exactly what you've predicted is being implemented, because of course the marketing organization is now part of that effort, because you need to be able to tell the story and show that you can vindicate the rights of individuals with their data in a simple user experience for your customers. We almost always see some member of the IT and engineering team that have to be part of that conversation. The security and the CISO's office is working very closely with privacy offices. And there are data governance organizations. We're seeing many, many more of these, in which a company has invested in some of the critical tools to be able to use the data more, use it ethically, understand their data. And that team now has to work very closely with and be using the same tools so that you have the insights from the privacy compliance side. So I understand exactly what you're saying, and we're seeing it from the technology side day to day as well.
Right.
Well, look, that's an important one. Let's then maybe go to the next one. And this one, Enza, is one that you have been proven correct on already. So your original prediction was UK would become a third party for data protection matters in 2021. Of course, that has proven to be correct. And so we're going to talk about that and some of the consequences. So maybe talk about this a little bit, why you thought this was true, and why what this may bring to the privacy community in the next year.
Justin, well, thank you for celebrating that prediction that was right. I would say it wasn't that difficult to write this prediction, because really at some point when we do this work, we do the prediction work in September, October. So, but already then you could see that actually the situation wasn't as such that actually the completion of the Brexit transition period was going to be particularly peaceful, or there was a collaboration between the two parties that was trying to happen, but we clearly saw that there was a clear challenge there, and data privacy was just one element of that conversation, an important one. There is and I would say, living in the UK, I've been following, of course, this conversation. I'm Italian, I live here, so it was a Brexit conversation was something that definitely I have been following. And the data protection aspects of it was definitely no less interesting than other things. Just, I think that generally data management related issues and what it means for your data flows, if, when the UK leaves the EU, all of that has been treated as I can say an afterthought, to be kind, but almost felt like this is not important. And then this has been creating a very misleading suggestion that these issues around data protection are not something that you need to actually be addressing, which is a mistake. Actually, these are very relevant issues. As a matter of fact, now since January 1st, the UK is a third country for data protection matters. The EU and the UK have agreed on a 4 months period, again, another 4 months of transition period where nothing is going to change. This period will be extended over another 2 months. So we are looking between now and June, fundamentally, to have this transition period. Nothing is going to change. At the end of it, or we have an adequacy decision by the European Commission, or every company that is engaging in transferring data of European or EU citizens into the UK for storage or processing purposes, they will need to find other ways to make sure that those transfers can still happen lawfully. And now there is an expectation that, we might there are many people saying, well, if we have the adequacy decision, nothing is going to change. That is true. But one thing that I like to say is that the adequacy decision might be even given at some point. However, it's not a decision that is set in stone. If there is, and to be completely honest, being here in the UK, I can feel that there is this appetite maybe to change a little bit the rules around privacy, maybe to make everything works a little bit with less protection, if I might say. If that happens, well, the adequacy decision, even granted, could always be taken away. I mean, it's not companies, this is the idea, the uncertainty is really the result of this. And the uncertainty means that maybe there will be an adequacy decision, maybe not, maybe there will be for some time. So the idea that for every organization to assess data flows at the moment, what they have, if any of those data flows are actually impacted by a potential lack of adequacy decision, they will need to think about the remedies. And of course, there is the standard contract clauses. There is the new guidance from the European Data Supervisory Board, Data Protection Supervisory Board, about the additional measures that companies have to take if needed. So organizations will need to run risk assessment to determine whether the country that they are sending data to offers adequate protection, whether the contractual clauses alone can protect that data adequately. And if not, they will need to apply safeguards, which is technology, encryption and other technology to make sure that the transfer is safe. One word I'm going to say on how organizations are focusing today on mapping those data flows. There is this idea that it's just direct flows. So if I'm in Germany and I'm sending data to the UK and that data is personal data, I will need to make sure that that transfer is compliant with whatever framework I'm using, or I'm using additional safeguards. The reality is that sometimes it's not your direct transfer. It might be that actually the German company is buying HR software from a company that is based in the US, and the company that is based in the US is serving that German customer with infrastructure that is based in the UK. That was a very common structure. It is a very common structure, but that is going to be impacted by Brexit and by the adequacy decision or the lack of it. So organizations need really to take a good look at those data flow maps that they have been drawing for GDPR compliance, for the privacy program. Go back to all those maps and make sure that you are identifying direct and indirect flows that have an impact, that might be impacted by the lack of an adequacy decision in the next 6 months or longer term even.
Yeah, no, Enza, I agree with you. On the priority list, the part that's interesting on this issue is, for now, there's just a status quo, right? So companies can kind of do business as if they were before. There is, of course, the need for the European Commission to run an adequacy process, because the commercial side of it, the actual local law governing data protection in the UK is identical, if it's either virtually identical or identical to GDPR. The essential equivalence on that side of it, I think, is for now likely to not be an issue, from an adequacy assessment. But this will be the first time, if the European Commission runs their normal process, in which Europe is assessing the national security and justice intelligence collection methods of the UK. And if in fact the European Commission applies their analysis in a consistent way, in the way that they've applied it for the US under Privacy Shield, there's some very tricky issues that are likely to come out of that. And it'll be very interesting to see how that process runs. But certainly I agree with you. This is another issue that has come up this year that will be interesting for companies to really deal with. And that brings us to prediction number 4.
Yes, and we change a little bit the focus here, as we are thinking more about a business dynamic, and especially we are focusing more on that relationship between the chief privacy officer and the marketing organization, relations that I have seen over time evolving, changing, sometimes being a very difficult one to have. Today, I would say much more collaborative. I have seen really that relation improving, maturing in organizations. I have got to the point that I have the opportunity to interview some CMOs that have actually said that the privacy that they have feared so much at the beginning actually is bringing them new opportunity to innovate, new opportunity to develop projects that they said we couldn't before. And at the base of that is actually that hygiene on data, the granularity of knowing who is consenting to this, who is not consenting to that. The idea that consumers can engage with you and maybe tell you, hey, I don't want to hear from you this way. I prefer my mobile rather than my email. I don't want to hear from you every month. Maybe I want to hear from you once in a while. That having that engagement going and having consumers and come to you and say, yeah, I want to have my data deleted, or I want to take a look at the data that you have. That has created more transparency. Companies that have embraced that have really the opportunity to have that transparency driving trust with their customers. And I think this is a strong idea that privacy understands and marketing really understand. And so this culture that is bubbling up finally, and this collaboration really is bringing new opportunities to organization. And this is the background of this prediction. Consent and preference management is definitely a topic that my customers have been prioritizing for a long time. I find often that organization, even if they have initial program or they are not very mature across their privacy program, sometimes they don't even have a privacy program, but they start from the consent and preference management. They tend to understand this is really important, is customer facing, is my face to the outside world. So they try to prioritize that. And also they understand that once I really take the data from a consumer, I want to make sure that everything works in the right way at the back end. So this is why they're prioritizing that so much. Marketing has understood clearly. If I start gathering data from a third party, a data broker, how can I be sure about their privacy communication, the risk mitigation strategy? How can I be sure that I can reach out back to these consumers and they're going to be happy to hear from me, or in other words, that they have a reasonable expectation of me as a business reaching out to them? So there are a number of questions around risk that really come up when you start to think about having this data coming from a third party, in which most often you don't have visibility. You cannot tell, you cannot risk assess really their own practices unless you find someone that is extremely transparent, which is very difficult to find. So the reality is that organizations understood if they can take into their hands the collection of consumer data and they can directly manage the expectation with the consumers, be there when the consumer wants to change something, be there when the consumers want to see data, be there to respond to whatever question that consumer may have, there are opportunity to improve that feeling of trustworthiness that you have between you as a business and your customer, your consumer. And this is why I think the CMO today not only understand very well why privacy is for them an opportunity to improve engagement with their customers, but also they want to be in that position to say, let's choose the tool together. Let's make sure that privacy and marketing are collaborating together for the right implementation of the solution that we choose. But fundamentally, having the opportunity to collect that data directly from consumers is really what they want and is really what is going to make engagement different. So that is our expectation, that 1 in 4 CMOs will invest in consent and preference management in 2021.
Yeah, so again, Anne's a very important observation. And honestly, I'm seeing, our team and our product includes a full consent and preference management solution. But part of why I think this is a really important observation is I think a lot more CMOs, to your point, are looking at the privacy obligations, not only as a check the box compliance item, but to your point, looking at it as an opportunity to engage with a customer at the right moment. When a customer tells you, don't sell my data, or tells you, please deliver my data, or I want to delete my data, there are ethical ways in which to engage with that customer to see if you can win back their business or engage with them in a broader way. And doing that ethically and using the right tools to do it is a really, really important part we're seeing from the CMO perspective, driven by this need for consent and preference management. But the second issue we're also seeing, and this will come into your 5th prediction, the CPRA or CCPA 2.0 has clarified, at least for companies that are covered by the California law, the need to give consumers the ability to effectively opt out of targeted advertising and retargeted advertising. The idea that this common practice you and I have seen every day, that you go to visit a consumer-facing site and then you start receiving, either seeing that ad for that product everywhere you go, or when you go to your social platforms that you're getting the ads surfaced to you, that you need the infrastructure that a consumer can come and clearly tell you, I want that to stop, and that you have actually made it stop. And the idea that you have to do that if you're a consumer-facing company, or that you're covered by California, and how you actually do that is often falling to the CMOs to figure out, because they're the ones that are driving targeted advertising, retargeted advertising. And I know you've written and talked about this, but it's part of the broader movement around ethical advertising to make sure that you're treating your potential customers and your customers the right way when it comes to their data. All of this really ties to this core focus for CMOs, that they will need the right tools and infrastructure to make sure that they are managing their customer preferences correctly and actually doing the right thing when a consumer says, don't sell my data, or this is the consent and preference that I have. So anyway, I think that's a really important one. And this brings us into CCPA 2.0 and federal privacy legislation. So I'm interested to hear your view on this one, Enza.
This one was one of the most difficult really to agree on, because of course, and I should mention this document is written in collaboration with a number of other analysts, of course, is not. So we do consider a number of potential prediction depending on our coverage area or the specific of our research. This one was something that definitely I think has legs, because so the prediction, first of all, we said CCPA 2.0 is going to pass. Again, we write this at the end of September, beginning of October, so we still didn't know at that point. And then there is this idea, right, that California has always, my US colleagues tell me that California has always been defining some of the standards for what happened at the federal level, has been the one to pass in many areas regulation that then has been followed by the federal government. So in that sense, really leading a little bit the way there. And I don't know, I think actually that even for privacy, that is going to probably be the case. Also, we know that in the US at the moment, there is a sentiment that California with the CCPA 2.0 might have some particularly stringent requirements, maybe not everyone wants to follow. So the idea of a privacy legislation at the federal level would also work as a little bit of a leveling effect. Now, I don't say that because I necessarily support that view. I don't, in fairness, but is a possible dynamic that we might see. So they need to create this federal bill in a way just to preempt some portion of that CCPA, if you want to be cynic and seen that way. But generally, I think then today also looking finally at what the composition of the federal government in the US, I think that might be an opportunity not to pass a federal bill in 2021, but definitely to start having a conversation, a serious conversation about what can happen in terms of a federal privacy bill moving forward. I think there are some of the conditions for that conversation to happen, for that process to start. I do am expecting to see that in 2021. It's also interesting to see how that then can have a relevance on an international, on the international stage, because of course the relationship in terms of data transfer between Europe and the US might also change if that happens in the US. So there are a number of things that are depending on this process, and I'm still comfortable to say that I believe this prediction will actually come through, and we might see really the beginning of the process for that federal privacy bill in the US to be introduced this year.
Well, look, I think this is an important one. I'm interested in where it's going to go from the federal privacy legislation side. one challenge I think that will be, and I think it could come up in federal privacy legislation that's COVID focused, for example, so we could get coverage there. In terms of a comprehensive federal law, I think it's going to be a bit of a challenge, among other things, just because the agenda is so enormously packed at this point. And between COVID relief, infrastructure investments in the US, and now, and you've probably seen, we have some complications from other legislative or Senate activity in the beginning. I think this is one of those items that may be introduced, but it may be hard to make progress on, Enza. The thing that I'm interested in your reaction to is, one of my predictions is CCPA 2.0 makes it much more likely that if Privacy Shield is put back into place, that the European Commission could recognize California as adequate, which is an interesting possibility. In other words, you could have one portion of the US recognized as an adequate regime by Europe, which, and you've seen in CCPA, there's actually a possibility for companies to self-certify under California law and oblige themselves. So it might be interesting to see whether California spurs federal privacy law, or whether more states kind of follow behind California with a similar regime, with Europe starting to recognize as adequate some of the regimes around the world. I don't know if you have any thoughts on that, but I actually think it is possible, given the way CCPA 2.0 is written.
Yes, that's a discussion that we tend to have. Clients to ask that question, and I think it might happen. Definitely, the thing that I believe is, or not believe, that I see already happening, that we saw a little bit in the past, is coming back, is really more state in the US following what California has done, meaning setting up this privacy protection within their state. This is something that has definitely been triggered by CCPA and CCPA 1.0, and then in these other versions. So I think there will be just common to see more states having their bills at the state level, which then increase that fragmentation issue that might lead again to actually urgency around the creation of this federal bill. Because of course, if you do business across US states, and you have all these different privacy legislation across the states, it might really be difficult sometimes to be able to have policies that would be applied across the board. So possibly that is the way. So there will be this increasing number of state level legislation for privacy. And then as a way to respond to increasing fragmentation, the urgency for that privacy bill might actually become even clearer than it is. So that might well be a way forward here.
Well, and I think that's where we now can transition over to some of the recommendations and takeaways, Enza. So, I know I might say two things, even for our phenomenal attendees today. If you have questions for Enza, please post them in the Q&A and we can take those momentarily. But Enza, I think this is an important set of takeaways for our viewers here today. Do you mind walking through those?
No, of course. So I have written these takeaways really in relation to the different prediction that we saw. One recommendation, again, is this is an attitude that I've seen in many places. We said is because you have employee data living in your systems, because you have collected that data for fiscal reason, because of labor legislation. It doesn't mean that the data can be taken and just moved somewhere else, change purpose, and do the kind of activity you want. I know that all privacy professionals that are listening to us know that very well. I would just warn that maybe their colleagues over in their CIO team, the analytics team, some of their HR colleagues might not have this idea very clear yet in their mind. So it's very important that there are adequate policies and controls in place to make sure that employee data that has been collected for a very specific purpose stay with that purpose and is not simply taken away from it. Another thing that I'm going to say in this respect is that many vendors that actually work to enable this kind of workforce analytics, very often they say, don't worry, we anonymize all data. help your colleagues over into the IT system, into the IT team or your HR team to really verify that claim of anonymization. Very often is simple pseudonymization. And if you need to comply with GDPR, that is not going to make any rules go away, or the rules will still apply. And then always keep in mind the idea of ethics and respect in the relation with employees, expressing why it's important to be transparent, also to do the right thing with that data. So make sure that the team has the adequate policy, the controls in place before initiating any sort of employee data analytics work. And also try to develop that privacy by design approach to workforce analytics. And personally, when Forrester started to write about workforce analytics, I made a clear point to my colleagues that we absolutely had to include privacy in the very first foundational report and research into these practices, because there is privacy at the very beginning of these initiatives. Cannot happen after all the analytics has happened, all the vendors have been chosen, all the third parties have been chosen, all the contracts have been written. You cannot remember at that point there is some privacy that you need to comply with. So privacy officers, privacy team will need to be incorporated into this project for workforce analytics very early days. And make sure you provide your teams with very specific guidance and very specific ways in which they can still do their projects, but making sure that they are mindful of all the privacy implication. And so again, a very strong call for collaboration there as a base. Make sure that there is a clear sense of visibility, accountability around your for privacy leaders, making sure that the organization is very well aware of what you do. Sometimes I meet privacy professionals, chief privacy officers, and tend to feel not 100% comfortable into a board and just presenting the program, articulating to a CMO the value that they are producing, articulating to a CFO which value the privacy work is bringing to the organization. Make sure you do that, because it's very important, because it's a conversation that the board wants to have in most cases. Sometimes they don't know how they have to approach this topic. But privacy definitely delivers much more than just compliance, can deliver on a number of value creation activity, innovation. It's important to have those conversations at the board level. So chief privacy officer, that is an opportunity, a great opportunity for you, and it's the time really to do that. And also there is this research that we are doing, but plenty of evidence that if privacy is done well, actually it enriches the customer experience. I am now working on some research around mapping customer journeys and really determining where are the key points in where privacy becomes this really value-adding element. And so again, collaboration with CX, but very important to understand, just put aside that idea that privacy is just going to diminish the customer experience. Actually not. If done well, there is evidence that actually is a very important improvement in the experience and contributes to create a feeling of trust and increase the reputation of the brand altogether. So it's a very strategic element there. Mapping out data transfer, this referred to the Brexit. I've talked about it. I've talked about this already, but really make sure you go back to your GDPR maps for data flows and make sure that you are identifying the transfer that will need to be remediated because of Brexit. One thing again around the CMO and the consent piece and preference management piece, they will be the one that will be choosing this technology, or will be closely choosing the technology with the privacy team. Make sure that you are working with the right vendors, that there is a clear understanding of what preference actually means. Sometimes happens that some vendor might be thinking that data subject rights is all they need to cover into a preference management portal. No, there is much more to it. So work with your CMO to really try and articulate what it's preference that you're looking for, in which way that can be part of the privacy portal, in which way that can be part of that interaction with customers, and make sure that the vendors clearly understand that this is as much as a compliance duty as an opportunity to really increase the engagement with your customers, so that you really can drive clear results out of these efforts. And again, prefer a number of examples there, but the idea is to reduce the reliance on third party when it comes to data. Focus on increasing your ability to collect the data directly from your customer and reduce the dependability on or the dependency on third parties for data. That is a key not only for risk mitigation and risk reduction, but also again the opportunity to engage directly, to orchestrate the relationship, to control and manage the relationship so much better than having a third party involved in it. And then if you also are thinking that there might be a federal privacy bill soon in the US, make sure that you are compliant with the requirement of CCPA 1.0 now. Run your gap analysis to determine which gaps you need to cover to be prepared for the CCPA 2.0. And that, I think, will put you in a very good spot for upcoming regulation or anyway for the new CCPA 2.0. So run your analysis and gap analysis there to understand which gaps you need to fill in.
And so that was just terrific. And I know we're coming to the end of the hour. There was a question that I think we could talk about a lot of these things, but there was a question from our audience I thought we might take as our last item for today. And you know, we talked about this a little bit earlier, but CCPA 2.0 includes in it one of the first audit requirements and effectively attestation requirements in the US. And there's going to be an entire rulemaking process around that in California in the next 6 months or so. And so one question we have today is, do you foresee that privacy attestations, similar to the way you have to do it in the US under certain other compliance laws like Sarbanes-Oxley, in which either the CEO or CFO or CISO or somebody like a data protection kind of attestation will become more important in the US in the next year? I mean, this comes back to a number of your different recommendations or observations and predictions. Do you have any thoughts on that in terms of the leadership of a company being on the hook for the ultimate certification in the coming years?
I think that might actually well happen. I think it's important, this element of that auditing and attestation for privacy. It's something that is important to include. It's something the GDPR to a certain extent has already in a different language, if you like. But definitely, I think that it is very possible that that attestation just become a very important part of the process. It is something that actually the regulator in the UK has been saying for many years, and I think it is indeed very important. People before the GDPR, people were running the privacy impact assessment really as a way, and the regulator in the UK was actually asking them to run this assessment really to understand their state of their privacy program, the state of their privacy practices. So it was almost, don't worry about coming to the regulator necessarily with that assessment, but use it as a way to drive that continuous improvement program, as a way to really determine the status, the maturity of your program. And probably this is also the other part of this. That is true, it will be, that auditing and that requirement, but also if an organization is able to look at itself and really determine where are we doing, where are the gaps, where are the things that actually we are not covering, where are the risks that we are not taking care of, I think is a very good way to drive budgets, to drive priorities, and to optimize the program continuously. So there is also this aspect of continuous improvement there out of this process that I think is another piece that can add value in the way we manage the program.
No, that's I think you're spot on, Enza. And look, I know you and I always could talk about many things. This has just been a phenomenal discussion around your core privacy predictions for 2021. A lot for our community to really process today. On behalf of our whole WireWheel team, I wanted to thank you and our viewers, thank you for joining us today to talk about this. A lot more we'll be able to cover as well in the upcoming year, Enza, and I look forward to having you back.
Thank you. It was a real pleasure, and I look forward to our next time. Thank you.
Thank you again, Enza.
Bye.
Bye.